Prior to 2005, the federal sentencing guidelines were mandatory, which gave the federal judges very little flexibility in their sentencing options, even when the result seemed unfair. Then came along Booker versus United States, which turned the guidelines from mandatory into advisory, meaning that the judge now had all the leeway to sentence the individual to whatever sentence was appropriate. Any term of imprisonment, probation, or supervised release. You're now watching the 9th part in my 10-part series where I discuss 10 of the most important Supreme Court decisions in criminal law. Again, you're now in part 9. We've started off with discussing your constitutional rights when it came to arrests, meaning your right to an attorney, your right to remain silent, and so on. Then we proceeded through trial, meaning you have a right to a speedy trial, and now we're all the way at sentencing. So again, we're now going to discuss Booker versus United States. If you're enjoying this series, give it a thumbs up. If you're new to Law Stash channel, hit the subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com/merch or shop.lawstash.com and check out the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, and other items. And because you're watching this series, type in the promo code 10cases to receive 10% off. Let's move on and discuss Booker versus United States.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're focusing on federal sentencings. I will tell you that the facts of United States versus Booker are not super important. Instead, all you have to know is that it transformed the federal sentencing guidelines from mandatory into advisory, meaning that the judges have to consider the federal sentencing guidelines but do not have to impose the sentence within the guidelines. They can always vary, depart, adjust, or move away from the guidelines. So today, I'm going to carry a conversation with you the same as I have with my clients prior to them making a decision whether to go to trial or plead guilty. Meaning that you have to know what is your exposure if you're charged with a federal crime. I've created a number of infographics. We're going to look at those today. They're going to help us with this task. So first, we have to focus on the crime. Again, the crime is written by Congress. It is a statutory authority. It has mandatory minimums and maximums, meaning that the maximum is a hard boundary. The judge cannot sentence you above the statutory maximums. It will also have perhaps a mandatory minimum. Not always, but some of the crimes do carry mandatory minimums. There are ways to go around that mandatory minimum, but if it applies, the judge cannot sentence you less than mandatory minimum. Let me give you an example. The most common example perhaps are drug offenses. Depending on the amount of narcotics, you might be facing a mandatory minimum, but there are ways around it. Safety valve, cooperation are two of the most common ways to get out of the mandatory minimum. But there's of course other ways. The very first thing you need to focus on is whether the mandatory minimum applies. What am I saying? Well, I've recently had a client who was facing a 10-year mandatory minimum sentence. But it all depends on the amount of narcotics and how the United States Attorney's Office charged the case. So through negotiation, I've convinced the prosecutor to drop the 10-year mandatory minimum case and instead recharge my client with a 5-year mandatory minimum case. What does that mean? It means that now all of a sudden my client is only exposed at a sentence higher than 5 years. Why did I do this? Well, my client would not cooperate, rightfully so, and my client was not safety valve eligible because of criminal history. So if those two options are out, then you have to convince the United States Attorney's Office to recharge you with a crime that does not carry a mandatory minimum sentence, or at the very least reduces the mandatory minimum. So that is your statutory authority. It has the maximum and the minimum. But the statute applies to anybody charged with a crime without looking at the person's individual characteristics and without looking at the criminal history. Then we move on to the federal sentencing guidelines. Those are advisory and more flexible. They're created by the United States Sentencing Commission, not Congress. And like I said, after 2005, after United States versus Booker, we now know that they're advisory, not mandatory. So the judge does not have to sentence you to the guideline sentence. They can always go outside of those boundaries. They're calculated based on a point system. I have previously discussed how to calculate the federal sentencing guidelines for many crimes, including drug offenses, immigration-related offenses, and financial crimes. So if you're charged with any one of those, go back, check out some of my older videos, because I've previously calculated many of the guideline sentences. But you will see a table in the book. It has 43 offense levels on the left and 6 history categories, criminal history categories. The intersection of those two items will give you months in prison. That is your guideline sentence. So again, if we're focusing on drug offenses, the offense level is usually calculated based on the amount of narcotics, and then there could be some adjustments, whether there was any violence, firearms used, the type of narcotic sometimes enhances the sentence or the offense level. But once you have the offense level and the criminal history category, the intersection will give you a guideline sentence. But the judge can depart or vary from that guideline. They can give you a sentence that's higher or lower than what the guidelines say, as long as they're within the statutory guidelines, the statutory rubric of the crime. What I mean? First, we're looking at the crime. You might see a very large range, and then we're focusing more with the United States Sentencing Guidelines. Let me give you an example. The statutory range might be 0 to 20 years in prison. So if we just look up the statute, it will say 0 to 20. But then the guidelines, once we consider the individual's criminal history and the offense itself, might say 7 to 9 years. So as you can tell, the guidelines are now narrowing us down to the sentence. But because the guidelines are advisory, the judge does not have to give you 7 to 9 years. The judge can give you 2 years, the judge can give you anywhere between 7 and 9, or the judge can give you 12 years, as long as he sentences you within the statutory rubric. So the job of your lawyer is to convince the judge, of course, to give you the lowest sentence possible. So those are the examples between the statute itself and the federal sentencing guidelines. But how does the judge know what sentence to impose? So the judge will look at the statute first, then the guidelines, and then we have to look at the 3553A factors. Here are the factors that the judge will consider. Even though the guidelines are advisory, judges must still consider Section 3553A factors and impose a sentence that is sufficient but not greater than necessary to achieve sentencing goals. The first thing the judge will do, of course, is look at the nature and circumstances of the offense. What happened? How serious is the crime? How much narcotics were there? Were there any firearms used? Anything about the crime. I will tell you, nothing good will be found there. Your lawyer should not be focusing on the crime itself. It is rare to find good information in this particular factor. Other than once in a while, you might have an imperfect dress, for example, or some threats that you've received. But other than that, usually we're not focusing on the nature of the crime. Instead, the argument that your lawyer should be presenting to the judge is found in the second factor: history and characteristics of the defendant. The criminal history, age, education, mental and emotional condition, family ties, employment, and community ties. So it is the information about you. So the first thing I do when I meet with my clients is I tell them, start working on character letters right away. If you have good character letters to attach to the sentencing memorandum, well, that shows community involvement. It shows that you have support. So work on that. I will tell you that I have a video that I've published in previous years where I've discussed some of the most important things that you should include in those character letters. So I will link that video below, or just go back and search for character letters on my channel. I've discussed it in great detail. I will tell you that this is where all the argument usually is when we're at sentencing. We have to convince the judge that you're a good person, that this crime does not define you. We have to look whether there are other collateral consequences. Are you a caretaker to your elderly parents or to your disabled child? What is going to happen to those individuals if you're taken into custody? We also have to focus on your employment history or your community involvement. All of those things have to be presented to the judge to separate you from other individuals who are charged with a similar offense. Number 3, the purpose of sentencing. The judge will look at the seriousness of the offense, promote respect of the law, provide just punishment, deter criminal conduct, protect the public, and provide rehabilitation. So again, some argument could be here. Are you an individual who needs rehabilitation? Is this crime committed because of your own drug addiction? Criminal conduct. Will you commit criminal conduct again? Again, your lawyer should present statistics to your federal judge explaining how likely it is for you to commit another crime. For example, I've previously had a client, I think my oldest client was maybe 75 years old. Well, I will tell you, statistically speaking, that individual will not commit another crime just because of his age. So again, here there's some focus that could be presented to the judge that you fall outside of the normal individuals that we see committing this crime. Number 4, the kinds of sentencings available: prison, probation, supervised release, fines, restitution, community service. I will tell you, often enough, the judges focus, of course, on imprisonment. But if you present a good alternative, the judge can consider. The guidelines are advisory, not mandatory, meaning that if a mandatory minimum sentence does not apply, and the judge consents you to any sentence he or she wants, even if the guidelines say 24 months in prison, you may be able to present a good mitigation packet, a good memorandum to the judge on why you deserve community service or some other form of punishment that does not put you in prison. So consider that as well. Number 5, the sentencing guidelines. Of course, the judge has to consider the sentencing guidelines. Number 6, pertinent policy statements. The guides from Sentencing Commission on applying the guidelines. If you look at any guideline, you will see at the end there's going to be some commentary. And so your lawyer should be reading that commentary to see whether we can pressure the judge again to sentence you to something outside of the guidelines, hopefully a lower sentence. Number 7, need to avoid unwarranted disparities. Similar defendants who commit similar crimes should receive similar sentences. That's the whole point of the federal sentencing guidelines. If we're in the federal system, an individual charged with a crime in California should receive the same sentence as in New York or Texas or Florida. It's a federal system. But again, each individual is different. So your lawyer should present to the judge, why do you fall outside of those norms? So what do I usually do? I look at similar sentences in our district. What do individuals receive for that particular crime? And then you can go through some of the information that was filed on those other defendants and see whether you can differentiate yourself. Are you an individual who should be facing a guideline sentence, or you're an individual who's completely different than those people? Again, this goes back to, of course, the second factor, the nature and characteristics of the defendant. I've had clients who've had seizures. I've had clients who've had medical conditions. I've had a client who did not have a kidney and had a hard time spending any time in prison. She would simply not get the care that she needs in prison. So there's ways to convince the judge that imprisonment is not the right thing here. And finally, number 8, need to provide restitution. Of course, the judge will consider in some crimes whether there's restitution to be paid to the government or to the victims. So those are the 8 factors. So here's a quick overview again. Number 1, the judge will look at the statute itself. What is the minimum and what is the statutory maximum sentence? Then the judge will focus and narrow in more on the individual. We're going to look at the offense levels and the criminal history category. And now we have the federal sentencing guideline range. And after that, we're going to look at 3553A factors and decide what exactly is the sentence. So hopefully this is the discussion you should be having with your lawyer. Talk about the statute itself, the guideline range, and what is your lawyer going to be arguing to the judge at sentencing. And this is the conversation, by the way, you should be having prior to making a decision to go to trial and prior to pleading guilty. If it makes sense to go to trial, do that. If it doesn't, well, you have to consider what will be argued on your behalf to the court at sentencing. Think outside the box. Don't always settle for imprisonment. Think whether there's other things you can argue to the court as an appropriate sentence. I hope you've learned something today about the federal sentencings. I know we didn't really talk about United States versus Booker because, again, the most important thing you need to know about it is that the federal sentencing guidelines are advisory, not mandatory. If you enjoyed this video, give it a thumbs up. If you're enjoying this particular series, go back, watch all of the videos. I think they're helpful. Again, if you want to learn about how to write a character letter, I have a video on that. And if you want to learn how to calculate your sentencing guidelines for a particular crime, either look up some of the videos I've done before, or if you have a particular question, don't hesitate to email me or write in the comments, here's the crime I'm being charged with, what are my guidelines? And I'm more than happy to help you. If you're new to the Law Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to shop.lawstash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And because you're watching this particular video, this series, as a reward, put in the promo code 10cases and you will receive 10% off. I will see you next week for the final video, the 10th part in my 10-part series where I'm discussing 10 of the most important Supreme Court decisions in criminal law. Thanks for watching. I'll see you next week.